Right, so now we turn to the paper itself, and I would like to invite Regenerate Christchurch to come forward initially so that we can get a sort of an overview of the actual process that we're dealing with here. I think having Regenerate Christchurch here as the proponent of the use of Section 71 would be incredibly helpful, not just from council's point of view, but also from a public point of view, so that people do understand the issues that we're grappling with today. Thank you, Ivan.
Thank you, Mayor. Good afternoon, councillors. I'd like to start by acknowledging that all of the deputations that you've heard today have raised a number of valid points. To be clear, no decisions have yet been made. Regenerate Christchurch has prepared and provided to strategic partners, including the Council, a draft proposal for comment before the Board of Regenerate Christchurch considers those comments and then decides whether to firstly make any changes to the draft proposal and secondly, whether to proceed with submitting the draft proposal to the Minister for Greater Christchurch Regeneration. If the Minister then decides to proceed, the draft proposal must be publicly notified to invite public comments on the draft proposal. Other processes will then need to be progressed, such as through the Reserves Act, which will be a matter for the Council to consider. Having received public comment on the proposal itself, the Minister will then consider and decide whether or not to approve the proposal.
Or not.
Or
It's
not.
a binary yes or no.
Correct. There are in fact several decision-making steps yet to progress, as well as opportunities for public input and feedback on the proposal. The draft proposal to use Section 71 of the Greater Christchurch Regeneration Act seeks to amend the district plan only to support Hagley Oval to deliver the intended regeneration outcomes and benefits to the city. The development of Hagley Oval was directed through the Christchurch Central Recovery Plan, which set out a package of projects that were not simply intended to replace what was lost, but to deliberately lift the level of aspiration for the city. The prosperity framework being developed by Christchurch NZ, sets ambitious goals for Christchurch, including a greater share of national GDP, attracting more people and investment, and increasing visitor spend. The Central City Momentum advice, which Regenerate Christchurch provided to the Council, and subsequent advice from Christchurch NZ has confirmed that Christchurch is experiencing falling business and investor confidence, that our city's economic growth is slowing, and as a consequence, Christchurch's relevance is fading as we lose market share of the national economy. If we are to attract people to live, invest, do business and visit our city, Christchurch must compete harder or otherwise risk investment, events and other opportunities going to other cities and regions. The proposed changes do not seek to reduce public access to Hagley Oval except when there is a cricket game that is being played. The proposed changes do not seek to create nuisance for the city. Cricket requires lighting in the modern game, and if well attended, will create vibrancy and noise. But this is not uncommon for events held in Hagley Park, such as concerts and fireworks. The Act defines regeneration as improving the environmental, economic, social and cultural well-being and the resilience of communities through urban renewal and development, and restoration and enhancement, which the Act specifically notes includes the provision and enhancement of community facilities and open public space. On the 7th of April 2016, when the Greater Christchurch Regeneration Act was passed, Parliament noted that this was a new phase of regeneration and was seen to have a broader focus than simply recovery. We were no longer in a state of emergency, and this is not emergency legislation. By encompassing a wider urban renewal mandate and focusing on the area's development opportunities and challenges, beyond those simply linked to the earthquakes, the legislation was expected to allow for the rebuilding of Greater Christchurch while also extending to urban renewal, restoration and enhancement actions which would improve the wellbeing and resilience of the Greater Christchurch community. Rather than replacing the standard powers and processes, for example through the Resource Management Act or the Public Works Act, these new powers were seen to offer additional mechanisms for the purpose of achieving the regeneration outcomes that were sought by the Act. This proposal recognises that the city has a purpose-built facility which is unable to deliver the fully intended regeneration outcomes and benefits to the city. We have the bespoke legislation to resolve these barriers for the purpose of achieving regeneration. And if approved, the changes will support Christchurch to compete harder for events that increase the vibrancy of the central city, grow our economy, and promote our city to a global audience. But they will not be the only changes that will be required through other processes.
Thank you. Can we start with this Hagley Park Management Plan and the carve-out that exists in the legislation, which we've heard about in the submissions? I don't know whether you want to just kind of refer to that in some more detail, because it doesn't seem to be sort of so well articulated in the actual draft application that we've seen. And I wonder whether, sort of now that we're having this conversation, and I know you're partway through a process, but whether that does raise some issues for you in terms of the way that you might present the matter to your board for consideration, and also whether you've thought about whether a sort of a more joined up cooperative approach around any sort of fast-tracking of, well, not fast-tracking, but appropriately timed processes around any changes to leases, should it be accepted for the next stage? Because you've said that your board's got to make a decision, and then the minister has to make a decision as to whether to proceed. At that point, it seems to me that we wouldn't want to wait for a decision before we commenced a process, which might well be required. It might not be, but it might be better to get it going in the same time frame if that's what's decided. So, sure. Yep,
thank you.
Confused question, but there you go.
So the proposal currently in front of councillors and has been provided to other strategic partners is a proposal to use Section 71 of the Greater Christchurch Regeneration Act to make changes to the district plan. If the minister should agree to progress, and it's the minister's decision to decide to progress, at the moment Regenerate Christchurch is simply seeking the views of strategic partners, then consideration would have to be made to other changes that would also be necessary to enable the changes that are being sought through the district plan to be given effect to. Those changes include changes that are governed by the Reserves Act. The Greater Christchurch Regeneration Act does not override the Reserves Act, but there is no point pursuing a process through the Reserves Act unless there is a willingness to consider the changes that are also required under the district plan. Should the minister make a decision to proceed, once the Board of Regenerate Christchurch has considered all of the views and determined that it still wishes to submit the proposal to the minister, Regenerate Christchurch staff, along with council officials and DPMC officials, have already started conversations about the way in which we would need to consider the various processes and how they are managed. And whether they are managed concurrently or consecutively is still a matter that needs to be determined, but all of this is subject to the minister making the first decision about whether or not to proceed.
So will you, if the board decides to proceed, will it be on the basis that that will be called out very specifically in terms of the advice to the minister?
I would anticipate that in providing its recommendation to the minister, the board would want to highlight any factors that would also need to be considered alongside the proposal. Okay. And acknowledging that the minister has particular decision-making powers, but to give effect to the intended outcomes, there are other processes which also need to be considered, which the council would have to turn its mind to.
Right. And just my other question is in relation to the timetabling of the approach. I just want to be quite clear that so if the minister were not to proceed to the next stage, have you actually talked to the cricket, the Cricket Trust, as to whether they would utilise the information that you've put together to support this in terms of a resource consent application. I mean, you'll make this information available as a backstop provision.
Thank you, Mayor. Absolutely. I'd like to acknowledge that the Trust has actually done most of the heavy lifting in preparing the information to, I suppose, convince Regenerate Christchurch that there was a compelling case to consider.
Right.
All of the work that has since been undertaken and also been done in parallel by Regenerate Christchurch is publicly available information.
Great.
And if the Minister were to decide not to proceed, all of that information would be available to the Trust to progress other options that might be available.
Right. But in terms of the advice you've received, that wouldn't meet the timetable required?
With the Trust's goals and objectives are to be able to secure the opportunity for Christchurch to host the benefits that would accrue from the Women's Cricket World Cup.
Yeah.
As you've heard from others, there are a range of other opportunities that would eventually come to Christchurch. I suppose one of the issues for Christchurch is that those opportunities would take longer to accrue.
Yeah. Okay. Phil.
Thank you, Ivan. I just want to clarify something I thought you were saying in your comments in answering the Mayor. Just around the Reserves Act, if the Council was to proceed to actually have a form of hearings through the under the Reserves Act, I understood you as saying, in fact, that would mean a change in the district plan. Is that what you, or did you not really mean that or say that?
No, sorry. So the Section 71 proposal seeks to make changes to the district plan.
Yes.
If there are other changes that are required under the Reserves Act, that would be a matter for the Council to consider. And we've been talking with Council staff, and it might be worth holding that conversation over until Council staff have had an opportunity to talk to the report.
Yeah. So can I also check, thanks Ivan for clarifying that for me, can I also check with you though, if in fact Council was of a mind to proceed that way, as well as the Section 71, in your view, would that have potential to be helpful for the whole process, given the high level of public interest in this?
Yeah, look, I think if we're trying to achieve the intended benefits and outcomes, we have to be aware of what all of the issues and barriers are. And the Section 71 proposal goes some way to addressing those. But in order to fully realise the benefits, there are other matters, as other deputations have identified today, that would also need to be traversed, and those would be matters for the Council to attend to.
Yanni?
I just wanted to check that as part of your process, are you recommending any changes to the blueprint or the Central City Recovery Plan?
No, we're not, because as is set out in the proposal, it's our view that the changes that we are proposing enable the Hagley Oval to operate in a manner which is more consistent with the Christchurch Central Recovery Plan.
Right. So given that the Central City Recovery Plan talked about it being a test venue and for domestic cricket, not one-day internationals, how do you respond to that?
So I would say that if you refer to the Christchurch Central Recovery Plan, it actually specifies that the Cricket Oval will provide a domestic and international purpose-built cricket venue.
The blue text right at the start that introduces it says providing Central Christchurch with a venue capable of hosting domestic cricket matches and international tests.
Yes, and if you continue to read the full text, Yanni, it goes on to say that the Oval will provide a domestic and international purpose-built cricket venue.
So we just go on that side of the page.
No, it says
No, it's in the
capable,
same paragraph.
Yanni. I mean, I don't think we need to have a putting words in people's mouth opportunity here. It says capable of. It doesn't mean exclusively for.
Yeah, it's just when we went through this initially, the whole purpose was a test venue, not a one-day international venue. That was quite clear from all the consideration.
Point of order.
Yeah, no, I'm sorry, Yanni.
Discuss what's on the agenda,
you know,
and not whether you like cricket or not.
Yeah, no, it's got... No. The point is that we've got Regenerate Christchurch here in front of us as the proponent of a plan. You've asked and you've had answered the question that you asked. No further questioning is required in this regard.
Just in terms of the other issues, are we really clear around what, in terms of district plan changes, things like car parking, the number of event days, for example, and the attendance, we're clear that those are district plan issues rather than management issues?
They are district plan issues, and that's why the rule package that we have provided, along with the proposal to the council and other strategic partners, sets out the specific changes in the district plan that would be required.
David?
This proposal requires the approval of other strategic partners. How many are there, and are there any indication of where they sit with that at the moment?
Sure. Just to be absolutely clear, the proposal seeks comment from the partners as opposed to approval. So at this stage, we are seeking comment from all of the strategic partners.
Being whom?
The strategic partners include Waimea District Council, Selwyn District Council, the Canterbury Regional Council, Ngaitahu, and the Chief Executive of the Department of Prime Minister and Cabinet.
Have you had any response from them as you?
No, they are all in the similar process to what this council is going through, other than the Selwyn and Waimea District Council confirming that they do not wish to provide a view on this particular proposal.
Thank you.
Andrew?
Thank you. I'm keen just to drill down a little bit further so that I've got a clear understanding into the matter that the Mayor raised and that Phil Clearwater followed up on as well, which is this question of the effective clause 63.5 of the Act. The Hagley Park Management Plan prevails where there's any inconsistency between it and a regeneration plan. Now, this isn't a regeneration plan, this is a Section 71 process, so there's probably a first question as to whether that clause applies to this or not. Secondly, the question is, is there an inconsistency of the type that was envisaged by that clause? Presumably, you've considered all of these matters in putting this proposal together or deciding whether to put this proposal together. So I'd be keen to get your feedback on that. But when you're saying that when you're suggesting, and I hope I get this right, that there may be other steps that need to be taken that would flow on from this Section 71 process, or that would need to occur alongside this Section 71 process, are you suggesting that there might be changes that would need to be made to the Hagley Park Management Plan to remove any inconsistency? Because that would then seem to be outside the spirit in which the legislation was created.
Sure.
So there's a few questions in there.
Thank you. I'll try to respond to your questions, and if the response doesn't fully respond, then I'm happy to continue to elaborate. Your first point, I think, which you made was that where there are inconsistencies, the Hagley Park Management Plan overrides or provides the guidance. I would say that in relation to what we are proposing, as I've previously mentioned, the Section 71 proposal seeks to make amendments to the district plan. The changes that we are seeking to the district plan, in our view, result in the district plan being more consistent with the Christchurch Central Recovery Plan. There is then the Hagley Park Management Plan, which also needs to be considered, and the mechanism for changing the Hagley Park Management Plan is a separate process. When it comes to operationalising and implementing what is required under the various documents, one of the challenges that Christchurch has experienced post-earthquake, but not necessarily uniquely post-earthquake, is the potential for inconsistency and interpretation and how those variations are applied when it comes to actually operationalising. So and I don't mean to speak on behalf of the Trust, and you're more than welcome to ask them, but I'm sure as the responsible entity for administering the Hagley Oval under all of these various mechanisms, consistency would be the most helpful approach and environment for them to operate under. In terms of what I believe is the second part of your question, that's a question that I, again, would defer until your staff were able to join at the table, because that question actually relates to a process that the council would need to consider and the council would be responsible for administering.
Yeah, I think, after afternoon tea, we'll have the staff, questions that are appropriately directed to staff, we'll ask of staff.
One point I would like to make, Andrew, is that the spirit in which we would be approaching this would be a very collaborative one, whereby everyone is clear on what part of the process and what role each of the parties is playing to achieve the intended outcomes. And as I've alluded to, there are a number of steps and processes that are required before you get to the eventual outcome. that rely not only on the decision-making of the minister, but also on responsibilities that appropriately sit with the council.
So do you believe that clause 63.5 does relate to the case that the proposal that we're discussing today?
Sorry, Andrew, would you mind repeating?
So
I don't have that in front of me.
63.5, the Hagley Park Management Plan prevails where there's any inconsistency between it and the regeneration plan. Do you believe that that clause does have influence or effect on the proposal that we're discussing today? Or because this isn't a regeneration plan, or because there isn't an inconsistency, do you believe it doesn't have effect?
So the Hagley Park Management Plan, the proposal was assessed against it as part of the putting together the proposal, the background information. The landscape architect that undertook that assessment came to the conclusion that what was proposed was not inconsistent with the management plan. So that's the first thing. The interaction with the Reserves Act that we have identified and that we do need to work with your staff on is around the lease that they hold.
Yeah, that's helpful. Thank you.
Thank you very much. James?
Actually, I think my question's better directed at our staff, so I'll wait for them.
Okay. So I think that's all the... Oh, Pauline?
Quick one. On 4.44, have you already undertaken some study into different design for lighting that could be lower and less impact?
Yes, so we have, as a result of conversations with your staff over the last few weeks and with the Trust, we are commissioning a preliminary lighting design to further explore whether the lights can be reduced in height and the luminaires reduced. This is we don't know whether they can yet, but we would like to explore it, and so the mitigation might be there.
Well, it says could be reduced around 2/3 of this size.
That was advice that council had received, so they're probably best to talk to that.
Yeah.
Right, but you have started that.
But we will definitely undertake the work to test the thinking that's been done.
So I'm getting an idea that the proposal that we have in front of us will take into account the advice that comes from council to facilitate the final advice that you provide to the board for their decision.
Absolutely.
Yeah. Right, and one of those, I guess, is the comparison between the impact of the temporary lights, which are authorised by resource consent, and the permanent lighting option, which you are promoting to be pursued through the Section 71.
Correct.
Yep, good. Right, we're on the same page. So I'm going to adjourn it for lunch. I'm going to adjourn. Sorry, I only ate half my lunch in the small amount of time I had available. We're going to adjourn for afternoon tea, and if people could be back here at 3:45 sitting at the table, and I'll invite council staff to take over the role at the end of the table at that time. Thank you.